Chriswell is with us, another installment of Marshall Law, and this radio program is intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking first the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell is on the line with us this morning. Good morning.
Good morning.
It's good to have you with us here today. I want to talk about a new law that is in place and ask you to explain it to me. It's a law that gives access to certain individuals to other people's materials, but in a very limited way, and obviously I'm not explaining it fully. I'm asking you to do that. What is the law called, and what's it about?
Sure. The law that we're talking about is the Uniform Fiduciary Access to Digital Assets Act, and this is a law that was passed by the legislature at the beginning of this month and signed into law by Governor Wolf on July 23rd, so very recent. And what this does, it addresses an issue that really has been a little bit of a thorn in the side of estate planners for quite a while. Of course, all of us, or most of us, are living a good portion of our life online now, and so we have photos and videos and documents that are stored on servers that we don't have control of, that are largely, usually in the hands of very, very large corporations. Same with emails and chat conversations. All of these things online that are controlled by corporations, that each one of those has their own user agreement that you've signed by putting a little check box, putting a little check in a box whenever you open the account, and so it's a mishmash of agreements, and none of them really are very friendly to the user in terms of what happens if I become incapacitated or when I pass away. How can anybody get access to these things? All of the family photos and videos, all of the emails and things. How can someone get access to a social media account to manage it or to shut it down if that's what needs to be done? So this has always been a problem, and we've tried to address it by using language in the documents that we prepare to try to give the agents acting under a power of attorney or an executor acting under a will or a trustee, to try to give them the ability to do these things. But you're constantly running into the brick wall of these terms of service with the companies, and this law seeks to address that.
Does it do it well?
I think it does. And so Pennsylvania is, we are one of the last states to address this issue. The vast majority of other states have access, digital asset access laws in place. So we had a lot of templates to look at and see what works and what didn't. And I think importantly, it seems like the legislators that worked on this brought in representatives from some of these big companies, right? I know Apple was involved. I know Google was involved. So you bring them in and say, okay, we have this problem, and how can we craft this legislation so that so that we can get what we need, and it's not something that is overburdensome or creating a whole lot of liability for the company. So I do think it strikes a balance.
Yeah, it's interesting. Folks might think that what is stored on the cloud or in some other online account is basically just family memories and things of that nature, and everybody else has them within the family, so there's no problem. And access to those materials would not be a problem either, but that's not the case. There could be big money involved here, couldn't there?
Sure. Excuse me. Yeah, absolutely. I mean, you've got, whatever types of media that you have saved in the cloud on someone else's server. It could be a manuscript of a novel you've been writing. It could be a song that's being written by an artist. There are all sorts of things that can be in the cloud that have monetary value that is going to need to be retrieved and managed when you can't do that yourself.
Yeah, so those issues will hopefully be resolved or certainly be met by this new law. You mentioned the fact that they could go to school on some of these other states and the laws that they have put in place. What are some of the difficulties that an attorney might come up against that are solved by this right now, this new law?
By the new law, so the law is effective 60 days from now, but it is retroactive, which is great because it applies to documents, wills, trusts, powers of attorney that were drafted prior to the law becoming effective. So that's a big help. You often have clients that need to access things like online banking for, mom or dad becomes incapacitated. Hey, we want to be able to do the online banking, but we need to get the username and password to be able to do that. I think that this law can assist with that. Like we talked about family photos. Accessing emails, you would think, why would I want to go back and look at somebody's email? It can be very, very helpful in determining the types of assets and debts and other financial affairs of a person, because we do so much through our email. So, being able to access those communications, and so what you have to do if you're a fiduciary, an executor, power of attorney, trustee. If you're a fiduciary, you make a request to what the law calls a custodian, which is the company that's holding that information, Google, Apple, whatever it is, and they have 60 days to get you the information. If they don't do that, the law then provides a mechanism to obtain a court order, which requires them to provide the information. So if you're dealing with a company that is slow or is less than cooperative with this stuff, you can actually go into court, have a hearing, and get an order from a judge that's enforceable. So that's hugely helpful.
This is another tool in your toolbox, isn't it, when it comes to these issues of estate planning, especially when someone becomes incapacitated or someone just out and out passes away without having somebody in place and legally able to. In the past, we always thought of it in terms of bank accounts and security boxes and things of those natures. But this really is a great tool for you to sort of unlock some of the assets of folks that can be really entangling. It
is. That's some one of the more difficult issues that I deal with whenever someone is appointed as an executor or power of attorney is assisting them with determining, okay, what are the things we need to deal with here? As I mentioned, where are the bank accounts? What investments did mom or dad have? What bills are there? Where are their insurance policies at? Whether it be life insurance or homeowners insurance or car insurance, all those things. And to some extent, you can get the mail forwarded and see what comes in the mail and determine it that way. You can look through the house and find important papers, but so much of what we do is online now that sometimes there is no paper trail. You can, really, I could open a bank account or an insurance policy and select paperless billing and sign an agreement online, and there may never be a piece of paper or a piece of mail saying where, to evidence that account. So it was becoming such a pressing issue, and now to have this law in place is going to be, I think, hugely helpful.
So for somebody who's in that position right now, being able to designate somebody to be their fiduciary, or that person who's going to represent them, should they become incapacitated or should they pass away, unfortunately, what are the steps that they need to take now, not just in light of this new law, but in terms of let's get up at the date here and get our estate planned. Let's stop sitting on the sidelines.
That's right. And coming up next month, and we always talk about it on this program, is August is National Make a Will Month. So we it's just a time to put it in the forefront of people's minds that how important estate planning is. And so, with respect to these digital assets, it's just one of those things that that we want to make sure that we're addressing, and it's just another good reason to start thinking about estate planning and putting documents in place. This new law, particularly the power of attorney aspect of the law, there is some language that needs to be in your power of attorney document to kind of activate all of the powers of the of your agent under this law. So it's something that we want to consider. And even if you have a power of attorney, previous one, it's something that you might want to consider having reviewed. Now, I've been putting in most of my power of attorney documents where I always have a conversation with clients about digital assets. So it's something that I've been doing for quite a while now. But it is something to take a look at. So it's another good reason. Hey, let's sit down with a lawyer and talk about wills, powers of attorney, trusts, estate planning issues. Or it's also a good idea, good reason to maybe have older documents reviewed.
Yeah, it's interesting. In our disclaimer, we say the law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Boy, this fits that definition, doesn't it?
It really does. And, I think it's something that a lot of folks, you can kind of take for granted, but the laws are so different from jurisdiction to jurisdiction, and really on just an ongoing basis, things are being updated as to keep pace with what we do in our everyday lives.
Yep. Don't be thinking that because you put a will in place with an attorney 5 or 6 years ago that you're up to date.
That's right. I always recommend reviewing these documents at least once every 3 years, and even sooner in the event that something changes in your life or there's a major legal change.
All right. So for those folks who don't have an attorney, who don't have any will in place, any estate planning at all, what's step one, and how do they get involved with you if they would choose to come see you?
The first step is to set up a consultation. For estate planning consultations, I don't charge anything for those, don't worry about getting every document together that you think you might need. Just come in and talk, and we can, decide if we need to get documents after that. But I think too many people wait too long because they're thinking, I just don't have enough information, or I'm not ready to do this. So the first step is to set up a free consultation, and you can do so by giving me a call at 724-465-5826. Stopping in our office in the R&P Cole Building on Church Street in Indiana, or going online and sending us a message on www.westernpalawyer.com.
He is Marshall Chriswell. Thanks for being with us this morning.
Thanks a lot. Have a great week, Todd.
You too. We'll see you. There's Marshall Chriswell. Good advice. It is the voice of Indiana County, WCCS 101.1 FM and AM 1160 and AM 1160 and AM